All right, we will go on the record then. The time is 1 p.m. This is a remand hearing for Deschutes County file number 2472593-A. My name is Tommy Brooks, and I am the hearings officer in this matter. Before we turn to the substance of the hearing, I'm going to turn things over to Ms. House to describe how the participation process works.
All right, good afternoon. For the record, my name is Caroline House, and I'm a senior planner with the Deschutes County Planning Division. The item before the hearings officer today is an application to address an issue that was remanded by the Land Use Board of Appeals and LUBA case number 2024-010. I'll start the hearing today by going over how the hearing will be conducted and then how members attending today can testify. I'll have a brief staff report. Then we'll move on to the testimony portion of the hearing. The applicant will testify first and we'll have 30 minutes. The appellant will testify next and have 20 minutes. And then other parties will be afforded 3 minutes. And lastly, staff can provide comments as well. After that, the applicant will have an opportunity for rebuttal. And lastly, there will be an open record period discussion and closing remarks from the hearings officer. And I do want to note that the hearings officer can eliminate or modify these time limits as he desires. So today's hearing is a remote and in-person hearing, so both participation formats are allowed. Before starting your testimony, regardless of how you're attending, please provide your first and last name as well as your mailing address. For our in-person participants, hearings officer Brooks or myself will call each of you up to the front of the room. Please come up to the table here and make sure you speak clearly into the microphone so your audio is picked up so the hearings officer can hear you. And so we can have it for the recording as well. And if you haven't already, please make sure you've written your name and contact information on the sign-in sheet that's over by the door. For our remote participants, you need to be attending via Zoom if you'd like to testify today. Hearings Officer Brooks will ask you to use the raise hand feature to notify him that you would like to testify. If you're on a computer or smartphone, you'll find the button in the bottom center portion of your screen. If you dialed in, you'll need to dial *9 to activate that raise hand feature. In addition to oral testimony, you can submit written testimony today. If you're testifying, please hand it to me after you've completed your testimony. And if you're attending remotely, you'll need to email that to me. My email is caroline.house@deschutes.org. Hearings Officer Brooks and myself are responsible for an orderly and respectful hearing. If you're being disruptive, you may be asked to leave. I'm going to pause here and ask if there are any objections to the hearing format that I just described. Being none, I will turn it back over to Hearings Officer Brooks for his hearing instructions.
All right, thank you, Ms. House. This application is being considered through a quasi-judicial process. I will consider only the factual evidence that is in the record. I will then apply those facts to any relevant provisions of the county's comprehensive plan and land use regulations. Of note, this is a remand proceeding, so the applicable standards and the approval criteria are narrower than what we would see in a traditional proceeding. The scope of the remand was identified in the public notice announcing the hearing and is described in the notice. The single issue on remand relates to whether approval of the application amounts to an improper collateral attack on a prior county decision. LUBA remanded this matter after concluding that the county's findings on that issue were inadequate. I am opening the record at this time to accept additional written or oral testimony regarding the evidence that is already in the record, so that remand participants can present arguments on whether the approval standard is met and whether or how to modify the findings on this issue. It is important that you direct all of your testimony only to the standards and existing evidence that relate to the scope of the remand. If you believe a standard or a criterion applies that was not listed as part of the remand notice, or if you believe the scope of the remand should be different, you may address the criteria and the scope of the remand. However, I urge you to do so in a way that explains why the criterion must apply or why the scope of the remand should be different, and to do so with specificity so that other participants may respond and so that I can address that issue in my decision. If you are seeking to offer new evidence that addresses the issue on remand, I need you to first make a request to open the record for that purpose. I will address any such requests as it arises, with the understanding that the county's code gives me discretion to open the record or to keep it closed. The failure to raise an issue with enough detail that enables me or the other participants to respond precludes your ability to appeal that issue to the Land Use Board of Appeals. Also, the failure to raise a constitutional or other issue relating to any proposed conditions of approval, again, with enough detail that allows me to respond to the issue, precludes an action for damages in circuit court. As I've noted, I serve as the county's hearings officer in this matter. In that role, my job is to be a neutral decision maker. Thus, while I have a contract with the county to serve in this role, I am obligated to remain impartial, and I do not represent the county's interests or the interests of any other participant. To that end, I'll state for the record that I'm not aware of any connections I may have to the applicant or other participants in this proceeding that would prevent me from remaining impartial. I have briefly communicated with staff, but only to discuss the particulars of the hearing today and not the substance of the application or the issues on remand. I do not have ex parte contacts to disclose. It is my obligation to preside over the hearing in an efficient manner. And so before we begin, does anyone wish to challenge my ability to hear this matter or to challenge the county's jurisdiction?
There's no one testing
All
your
right,
ability.
So with that, we'll start with the staff presentation.
All right, so just beginning with the location specific to the remand, we're talking about the Highway 97 ODOT right-of-way, south of the Baker Knott Road interchange, all the way down to the High Desert Museum's property on the east side of the ODOT right-of-way. So as I mentioned previously, the applicant has requested the hearings officer review the issue remanded by the Land Use Board of Appeals. And that was specific to the Deschutes County's hearings officer's declaratory ruling, concluding that the subject property in this case is zoned rural residential. Specifically, LUBA found remand is required for the hearings officer to adopt adequate findings addressing petitioner's argument that the declaratory ruling application is a collateral attack on the final and unappealed way station decision. And the way station decision in this case was a Board of County Commissioner decision that was issued in 1999. As part of that decision, the Board of County Commissioners found the subject property, this section of Highway 97, was zoned forest use. All of the materials for this application are published on the website on my screen. I do want to note that the Win Links Family Trust submitted materials yesterday. Those have been uploaded, and I've checked my inbox, my physical mailing inbox and my mailing inbox, that I haven't seen any additional materials that have been received. So everything's current at this time and published on this website. That concludes everything I have for my staff report, but I'm available for questions from the hearings officer.
Okay, thank you. I do not have any questions for staff at this time, so we can bring the applicant up.
Sure. Can you hear me okay?
And hear you just fine. Thank you.
All right. For the record, David Amonton. Address is 63055 North Highway 97.
Yeah, my name is Ken Schunkweiler. Address is 63055 North Highway 97.
So good afternoon, Officer Brooks. My name is David Amonton. I'm the planning manager for ODOT Region 4, and I'll get this figured out. And I'm here this afternoon with Ken Schunkweiler. He's our principal planner. We're also joined, I think, remotely by Stacy Postgate, who is our counsel from the Department of Justice. And we are here this afternoon to discuss ODOT's remand application for the Lava Butte path. At today's hearing, we'll review our remand request and the case background. We'll address the collateral attack argument at the center of LUBA's remand decision, restating the position of both ODOT and Deschutes County that ODOT's application is not a collateral attack on an unrelated 1999 Deschutes County land use decision. And we'll conclude with a request that the county address the sole issue on remand. So LUBA's sole instruction to the county in this matter is to adopt adequate findings addressing, I see a hand raised.
If that's okay, excuse me, Officer Brooks, there is a PowerPoint presentation that was going to be part of this, and it's not showing up on my screen.
I'm not seeing it either if there's one being broadcast in the room. Looks like it's up now.
Okay,
Thank you.
that's helpful. Okay, so I'll just kind of pick up where I left off. So we're here to pick up on LUBA's instruction to the county to adopt findings addressing petitioner's argument that ODOT's application is a collateral attack on the 1999 way station decision. All other decisions made by the hearings officer have been affirmed by LUBA in the Court of Appeals. And on this remand, ODOT seeks a decision by the hearings officer and findings that ODOT's request for a declaration that the subject property is zoned rural residential 10 is not a collateral attack on the 1999 decision. Deschutes County Code sets forth the local requirements for proceedings on remand. It requires the county to conduct a hearing on remand and states that the scope of the proceedings should be consistent with County Code 2234 as well as state law. County Code 2234-040A states that the hearings body shall review those issues that LUBA and the Court of Appeals have required to be addressed. And to that end, remands are supposed to work like a funnel where issues that LUBA and the courts have resolved are sifted out, and only those issues that LUBA remands are left to be addressed. So in these proceedings, the remand should be narrowly tailored to address those issues that LUBA and the Court of Appeals have required to be addressed and no others. I'll now transition to a discussion of this case's background. So ODOT originally applied to Deschutes County for a declaratory ruling under case file 247-23-00302-DR. And in its application, ODOT argued that the subject property is zoned rural residential 10, that the project is a class 3 road and street project, that class 3 projects are an outright permitted use in the RR10 zone and require no land use permits, and that ODOT's application did not constitute a collateral attack on the 1999 decision. On January 26, 2024, this hearings officer issued his decision affirming each of ODOT's positions. Winlinks Ranch Trust appealed that decision to the County Board of Commissioners, and on February 22nd, 2024, the board adopted order number 2024-0008, declining to review the hearings officer's decision. Winlinks Ranch Trust then appealed the decision to LUBA. And in their petition for review, petitioner appealed 3 primary issues. The first assignment of error is actually separated into 2 sub-assignments of error. The first sub-assignment is that argued that the hearings officer did not address Winlinks' arguments that ODOT's application constituted a collateral attack on a prior land use decision. The second sub-assignment of error argued that the hearings officer erred in finding that the doctrine of issue preclusion did not bar the county from determining that ODOT's property is zoned RR10. And then in the second assignment of error, petitioner argued that the hearings officer erred in declaring that the property was zoned RR10 due to an incorrect application of Deschutes County Code 18-12040 to resolve an uncertainty. And finally, in the third assignment of error, petitioner argued that the hearings officer erred in declaring ODOT's proposed project a class 3 road project and an outright permitted use in the RR10 zone under Deschutes County Code 18-60020F. In addressing the petition for review, LUBA affirmed on the following issues: that the doctrine of issue preclusion does not bar ODOT's application seeking to establish the trail area zoning, that the hearings officer correctly applied Deschutes County Code 18-12040 to conclude that the property is zoned rural residential 10, and that the hearings officer correctly applied Deschutes County Code in determining that the project is a road and street project and adopted adequate findings, further explaining that the project is a Class 3 project for which no land use permit is required. This case was remanded on a single narrow issue, the first subassignment of error, in which petitioner argued that the hearings officer did not address their argument that ODOT's application constituted a collateral attack of a prior land use decision. And in remanding, Luba noted, we agree with petitioner that remand is required for the hearings officer to adopt adequate findings addressing petitioner's argument that the application is a collateral attack on the final and unappealed way station decision. Luba is only directing the hearings officer to address findings related to the first subassignment of error. And as Luba discussed on page 17 of its opinion, even though it sustained that error, it does not have any bearing on the other assignments of error. Winlinks Ranch Trust appealed Luba's decision to the State Court of Appeals. And on November 8th, 2024, the Court of Appeals issued its final judgment affirming Luba's decision without opinion. Per Luba's direction, as affirmed by the Court of Appeals, ODOT initiated this remand proceeding with Deschutes County to address that single narrow issue on remand. I'll now defer to Ken to discuss petitioner's collateral attack claims as well as ODOT's arguments refuting that conclusion.
Thank you, David. So again, the only item we are here to address today is whether ODOT's application for a declaration that the property is zoned RR10 is a collateral attack on a 26-year-old land use decision to build a way station. So let's start with the definition of a collateral attack, which is an attempt to impeach the decree in a proceeding not instituted for the express purpose of annulling, correcting, or modifying the decree or enjoining its execution. As ODOT explained in its December 13th, 2023 memo, a final decision by the county on this application that the subject property is RR10 would have no impact, positive or negative, on the validity of the 1999 way station decision. We will present 4 arguments refuting the petitioner's collateral attack claim. First being that ODOT's application to Deschutes County is not a collateral attack in fact. And 2, it does not meet the legal definition of a collateral attack. 3, and furthermore, Deschutes County Code encourages applicants to resubmit land use applications rather than to initiate an appeal. 4th and finally, even if ODOT was attempting to collaterally attack the 1999 way station decision, the hearings officer is not bound to follow a land use conclusion that was made in error. All arguments and content that we are reviewing today are already in the record and available online. So starting with our first argument, this is not a collateral attack. In fact, let's compare the 2 cases, starting with the 1999 way station application. So the way station application was a conditional use permit, whereas the Lava Butte application was a declaratory ruling application. The way station application involved the construction of a way station, and in the Lava Butte path, we're proposing building a pedestrian and bicycle pathway along the US 97 right-of-way. The way station application did not apply Deschutes County Code 1812-040 correctly and assumed that the property was zoned F2, whereas the Lava Butte path application correctly applied Deschutes County Code and found it to be RR10 zoning, which was affirmed by Luba in the Court of Appeals. The 1999 way station application is an unrelated proceeding 26 years ago, and ODOT is not challenged, and the denial was not based on the property zoning. With the Lava Butte path application, ODOT is not challenging the way station decision. Our second argument is that legally, this is not a collateral attack. We agree that the collateral attack on the land use approval should not be permitted directly or indirectly by denying future permits, but that is not the case here. The legal concept of collateral attack in the context of land use is used primarily to reference an act or challenge by an opponent to a land use approval after the approval is final. This is the fact pattern in the case cited by Windlinks, Ganson versus Lane County, as well as others, including Holman versus the City of Warrenton, Tilka versus Clackamas County, Moore versus the City of Fairview, Doney versus Clatsop County. Barring a collateral attack of a prior land use approval protects the integrity of that approval, and we agree it should not be permitted. However, the finding that the property is RR10 does not reverse the 1999 board decision. It does not impeach the 1999 decision decree, nor does it annul, correct, or modify the previous decree or enjoin its execution. The denial to construct a way station permit remains the same. Most importantly, even if the 1999 case had identified the subject property as RR10, ODOT would still have to apply for a conditional use permit because a way station is not an outright permitted use in the RR10 zone. County code would still have required a CUP, even if it was zoned R10. Our third argument, again, collateral attack does not apply because of Deschutes County Code 22-28040. This section of code contemplates that an applicant may refile denied land use applications. Deschutes County Code 22-28040 is an acknowledged land use regulation upon which applicants in this matter were entitled to rely. The intent of the provision is to encourage applicants to accept decisions of denial at the early stages of the land use review process rather than appeal decisions of denial. This encourages applicants to revise and improve land use applications to address issues that resulted in denial rather than to challenge issues related to the denial by filing appeals with the Board of County Commissioners, LUBA, and the appellate courts. These principles are reaffirmed in Bishop versus Deschutes County, which found that applicants can resubmit applications and are not precluded from doing so. Our fourth and final argument is that the hearings officer is not bound to an erroneous decision. Finally, and singularly significant here, the hearings officer is not bound to the 1999 waste station decision because there is no requirement that a challenge decision be consistent with a past local decision if the prior decision was based on an incorrect interpretation of the applicable standards. Based on Reader, it was proper for the hearings officer to review this issue de novo. Simply acquiescing to the prior decision with no independent analysis would have been an error. Accordingly, the hearings officer was well within his authority to find that parcel 1 is zoned RR10, regardless of the Board of County Commissioners' 1999 findings, because such findings were made based on staff and ODOT's erroneous interpretation and application of Deschutes County Code 18-12-040A. Put simply, the county is not required to follow a past wrong decision. In response to the letter submitted by Windlinks Family Trust on March 17th, ODOT does not object to reopening the record for further discussion about the one issue on remand, which is whether or not ODOT's application is a collateral attack. But we do object to opening the record to allow any arguments or documents that ODOT misrepresented that in 2021 it had a different understanding of the zoning. What ODOT thought in 2021 about the zoning isn't relevant whatsoever to whether its present application is a collateral attack on a decision made in 1999. And more importantly, Windlinks is asking to open the record solely to prove some misrepresentation by ODOT. But we ask, where is this misrepresentation? There is nothing subversive in ODOT relying on a county planner's assessment that the zoning was F2, a planner who coincidentally also worked for ODOT as the planner involved in the 1999 waste station application. All this shows is that because of one planner's mistaken review of county maps and code, ODOT is now in its 5th year of planning, not building, but planning. Less than 2 miles of a bike and pedestrian path on public property. This is just a further attempt to re-argue the zoning of the property, an issue which has already been resolved by the county, LUBA, and Court of Appeals. Again, ODOT does not object to reopening the record for further discussion about the one issue on remand. However, our review of the WinLink submittal indicates that it, one, contemplates no new arguments related to the record or single issue on remand. Two, attempts to relitigate whether the hearings officer correctly applied RR10 zoning, which has already been decided by Deschutes County and affirmed by LUBA and the Court of Appeals. And three, reinforces that ODOT and the county have held conflicting opinions about the property's zoning. If anything, that dispute further supports a correct application of Deschutes County Code 18-12-040 and the need for a declaratory ruling in the first place. ODOT held an opinion and the county held an opinion. Those opinions changed over time when we looked more closely at the GIS maps, Deschutes County Code, and the original map exhibit. None of this points to a misrepresentation, it just points to a process. These emails pointed to the fact that there was a dispute over the zoning and the previous need for a declaratory ruling. In summary, ODOT requests that the hearings officer address the single issue on remand and issue findings that ODOT's request for a declaratory ruling under Deschutes County Code 2240-010 is not barred as a collateral attack on the county's denial of ODOT's application to develop a weigh station on the same property. And with that, we conclude our presentation. And thank you, and we're available for questions.
Right, thank you. I think I just have one question so far. I'm not sure who to address it to, but on your fourth point, in terms of the, which is, you went through the factual differentiation and the legal differentiation. You talked about being encouraged to reapply. Your fourth point was about not being bound by prior decisions. I understand the main point that each application was supposed to be reviewed on its own merits. But at the same time, the way you've described it almost feels like the collateral attack doctrine would never apply, which I'm guessing from LUBA's decision, it does. I mean, LUBA wants additional findings on it, and there is case law about collateral attack. So could you tease that apart a little bit more about why the not being bound by prior decisions and how that's differentiated from the doctrine of a collateral attack and how that should be used?
So I'm not sure who the question was directed to, whether it was Ken or me or Stacy, but I'll try to chime in. I think the argument that we're making in argument number 4 is that when a decision is made in error based on incorrect facts or an incorrect interpretation of the facts at hand, then future bodies are not bound to that incorrect decision, whether it's based on incorrect facts or incorrect interpretations of those facts. That's our interpretation of the case law.
Thank you. That's a helpful clarification. I think I understand your position better. I don't have any other questions for the applicant. You'll of course have a chance to come back on rebuttal if that's necessary.
Okay, thank you.
Thank you.
Hearings Officer Brooks, would you like the appellant to come up next?
Yes, I was just sort of checking the list. Yes, we'll have the appellant come up.
Good afternoon, Mr. Brooks. Chris Koback again, on 937 Northwest Newport Bend, Oregon. I'm here on behalf of the WinLinks Ranch Trust. We're only here to address one issue. It's the issue that LUBA remanded, whether the declaratory ruling application in 2023 was a collateral attack on a prior non-appealed decision. And first, I do want to formally request that you do open the record for the new evidence that we submitted in which ODOT talked about. I just I think I just heard ODOT say they don't have an objection to reopening the record for that, but I just want to make sure before I start talking about it. And also, if you have questions about why we believe it is so important to reopen the record for that material as it relates to this issue, I want to address that now.
Thank you. As I said in my opening comments, I would address this as it came up. So let's talk about it now. I saw the letter that you submitted to the county. I read your cover letter. I have not yet looked at the supporting materials. So let me ask a couple of questions because there's things that I just wasn't tracking. One, you kind of started the whole argument off as this is you need to open the evidence or sorry, the evidentiary record in order to prevent a procedural irregularity, but I couldn't tell what the irregularity was.
Well, what we believe the irregularity is there was important information that was relevant to whether or not this is a collateral attack. For example, in the record that went to Lubat, pages 228 and 229, we specifically argued that declaratory ruling application, the one we're here on, was being used as a backdoor attempt to collaterally attack the 1999 zoning decision. And my notes reflected ODOT's position was, no, that's not it. We just have more accurate maps. And there was information that we got later in a public records request that we believe shows that we were right. ODOT knew, the applicant knew back then when we raised that issue that this was a collateral attack. For example, the first email from February 2021 with ODOT and the county is telling ODOT, my client, Winlinks Ranch Trust, they're relying on this 1999 decision and its effect. That's a big part of their claim. And then the next email from Mr. Russell, who was the planner in 99 for ODOT and the planner for senior planner at the county in 2021, he writes to ODOT and he significantly, he uses the same GIS maps that ODOT told you were the basis for their revelation that this is, oh, we just have better maps. Same maps Mr. Russell had. And he's telling ODOT, based on these maps and that 99 decision, you can't do this. You might be able to do a conditional use, but you can't do it because that it's F2 zone. And then the response from ODOT in August of the same year, they never said, no, you're wrong. These maps show something different. They agreed that they had limited options at that point in time, and a declaratory ruling challenging that zoning decision from 99 was not among them. So we believe that information is highly relevant to whether or not this application was always designed as a collateral attack on that prior decision. And I think it is, that's critical. And we think that because the county had all that, it would be procedurally irregular not put in. For example, to make sure that the participants had all of the relevant information, the county put in the maps, the old maps going back to 1982, because they wanted everybody that participated to have a full, fair opportunity to vet the issues. Now, if you read goal 1 of the county's comprehensive plan, it's consistent with that approach. Let's give everybody all the information so we have a fair, open procedure and get to the right conclusion. We believe that those documents that were particularly relevant to our opening position at the record 228, 229 should have been put in the record by the county. We should not have had to go and get public records from the state, which took a long time to discover this information. So that's where we think it's a procedural irregularity.
Let me respond to part of that before I get to some other questions. One is, I think the way you've described it, it sounds like though it's different information supporting the same arguments that you made. It's just coming from a different source in terms of, what people at the time thought the zoning was, how they moved forward. So I'm not seeing the procedural irregularity part of it. There was a record produced last time, for this matter. These same arguments were made. This feels like just additional evidence to the same argument. And I guess that leads to the next question. For the declaratory ruling, I don't see kind of like an intent component. So are you suggesting that I read into the declaratory ruling that the applicant's intent in using it was relevant?
I think it is relevant that those documents show that we are correct, that this is a collateral attack. And I think it is not irrelevant that documents that show that the applicant believes we are correct is irrelevant to this proceeding. It demonstrates that, it demonstrates, one, if you've got to pick between two arguments, our argument is this is a collateral attack based on the evidence. You can look at the record and see this is a collateral attack and everybody knew it. And their position is that we're not collaterally attacking. It's just we got better mapping. Well, the evidence that shows that they had the better mapping when they took the position that they couldn't challenge that decision, I think is highly relevant. So in a way, yeah, knowledge that their position that they stated to you in the other hearing was legally wrong, I think that is relevant. And it's important to the integrity of our process.
The other question I have for you is kind of related and goes back to some of your initial comments. Is it sounds like you're asking me, and in fact, I think your letter expressly makes the request that I direct the county to put certain information into the record. I guess I don't know what my authority as a hearings officer is to require parties and participants to develop a specific kind of record. That's kind of up to each party.
Right. Yeah, I agree. It's hard for you to make that order, but you can see our standpoint. We're finding some documents that we believe are really highly relevant and help our position. And we honestly don't believe that's all of them. Something happened to change from you can't do this to and you can't file a declaratory ruling to change the zoning to, well, you can do it. And we certainly, we would implore you, we get there's limitations, but we would certainly like the opportunity to have a fully developed record to see if there's more information out there in the county files, just communications between ODOT on this application and how this position changed. I think we've cast a legitimate question on how this got from you can't do it this way, you need to do a text amendment or a zone change to, yeah, change the zoning, challenge that decision. It doesn't mean anything anymore. We think that's wrong. It should be explored. So we made the request.
Well, let me tell you where I am on it. Going back to the LUBA decision that resulted in the remand, and it's actually in their discussion of the second assignment of error, but they talk about what the first assignment of error is, and it says petitioner's first subassignment of error under the first assignment of error is a findings challenge only. And then it goes on to say the petitioner does not assign as error or otherwise develop an argument that the challenge decision is a collateral attack. So having read your letter and the LUBA decision, I think the issue in front of us is very narrow and it's a findings question only. Like I said, my sense is that the evidence that you would like to put in is just additional evidence of the arguments that you've already made. And in fact, at least the way you described it, it's all evidence that existed at the time that we had this first record. So I'm gonna keep the written record. I'm gonna keep the evidentiary record closed. I think the first part of your letter makes your arguments, and I will consider that, but not the new evidence.
I respect that, but if I could just comment on one thing is if you read the briefing before LUBA made those statements, the findings we said were missing were all of them. We said there were no findings on collateral attack. You only made findings on issue preclusion. So my view is you have to make findings on whether this is a collateral attack, and this evidence is relevant to those findings. That's our position.
Yeah, I don't have the LUBA briefings in front of me. I've got LUBA's decision and I've got the record. So I'm basing it on the actual language of LUBA's decision. But you can continue.
Okay. Well, so on whether it's a collateral attack, first of all, ODOT didn't tell you what the law is. The law, as LUBA has recited in Ganson and the North Bend case, is that a decision not appealed, whether procedurally or substantively wrong, cannot be collateral attacked. So your comment you just made in closing, the question you asked of ODOT is really important. Under their position, anybody could come in and say, I think that decision's wrong, so I can challenge it. Why have collateral attack? Why do we have the doctrine if their position is correct? LUBA has, and the courts, I think, have clearly said, here's how it applies. If you don't appeal a decision, even if it's wrong, you can't come in later and challenge that same decision. Now, let's get to the scope of what collateral attack addresses. It doesn't have to be a direct attack on reversing the prior decision. Look at Ganson. In Ganson, Mr. Ganson went in 2002 to get a building permit. And he got it based on, and in it was a finding that his property was a lot of record. And that's an important foundational fact because you have to be a lot of record to get a building permit. And you have to be a lot of record to get a lot of permits. And so then 20 years later, he goes in on a totally unrelated request. And he says, I'm going to do a lot line adjustment. And I can because I've got a lot of record. And the hearings officer says, no, I don't think it's a lot of record. So he tried to make a change to the foundational fact. Now that change would not have affected the building permit. The building's already built. But yet it was an important foundational fact that because it was already determined on that property in 2000, it couldn't be challenged. Whether or not that lot of record decision in 2002 was right, wrong, or in between, it could not be challenged. And so I think they have the whole concept incorrect. And on how important the zoning is, we pointed this out before. To say that the zoning didn't matter in 1999 ignores the whole fundamentals of land use. The zoning determination on a piece of property is legally analogous to a lot of record. It's one of those foundations that you have to have. It determines what uses are allowed. It determines the criteria. It determines the evaluation of that criteria and then any conditions that are required. Without that foundational fact, you don't get off square one, just like a lot of records. So when the county made this final binding determination of this foundational fact, it was incumbent then on ODOT to appeal that issue or live with it. Like I said, under the rule, you can't come back 20 years later and say, I don't have to live with that because I think it was wrong. That undermines the whole concept. And it's not just a doctrine that is there for applicants to cut opponents off. In Ganson, it was used against the government. The local government has to live with that doctrine. I didn't find a single case cited by ODOT that holds that collateral attack doctrine on an issue, foundational issue like this, is limited only to certain parties. Now, for example, what if in 1999, ODOT went in and got approval for a facility based on whatever the zoning was? And it was, the zoning was critical. And then 20 years later, they said, well, we want to modify that. And we came in and said, well, you can't. We think that zoning determination was wrong. And now we think the zone is a different zone. And under that zone, you cannot get your modification. Well, ODOT would have said, oh, that's crazy. That's a collateral attack. That zoning issue was decided. We say, well, no, but it was wrong. Under your theory that you just heard today from ODOT, because it was wrong, we're never stopped from challenging that zoning issue. So why wouldn't it apply to them? There's no legal reason, no legal justification that ODOT has given you that collateral attack shouldn't apply in this very situation. It should apply. It's a doctrine. It doesn't matter who the parties are. It's a doctrine that protects the integrity of that prior decision and anything conclusively determined. And so that's the way I think the law really requires the hearings officer to make findings that decision wasn't appealed. It made a determination of that foundational issue, and you cannot collaterally attack it, whether you come in on a declaratory judgment or any other procedure that staff may allow you to come in on. There's limits on what you can and cannot challenge, and that's one of them. So as long as we can't talk about the other information, I'll conclude there unless you have questions of the appellant.
I don't think I do. I understand your arguments. I appreciate you walking me through the effort to open up the evidentiary record, but I don't have any further questions.
All right, thank you.
Ms. House, are there others who have signed up to testify?
Mr. Roth, are you going to testify? No, there's no one else in the room. And I'll ask anyone attending online that's not the applicant to use the raise hand feature if you were hoping to testify. I'm seeing no raised hands, so no one else, but staff does have some comments if now is the appropriate time to.
Sure, yeah.
I'm actually going to ask my manager, Will Groves, to come up and provide some comments
Okay.
for your consideration. So just a moment.
Good afternoon, hearings officer for the record, planning manager Will Groves. I may not have a comment here. I want to check. Were we to be discussing the status of Peter Russell's prior correspondence on this matter? I had some comments on that. It sounds like the record has not been reopened for that, and thus I would not either be able to or need to comment to that. Is that correct?
That is correct. I'm not gonna, that it's been presented, it's not gonna be included in the record, so there is no need to discuss it.
Perfect. That's all I had. Thank you.
All right, does the applicant wish to do a rebuttal?
No, we have no further rebuttal.
Okay, thank you. All right, I'm gonna close the hearing then. I think this is not as straightforward as an issue as I think I would want it to be on remand. I think this is going to require a little bit of thought and to tease apart these arguments. So I appreciate the information that's already been provided in the record. I haven't heard any requests to keep the record open. I think everyone's had their say, and like I said, I'm not going to open the evidentiary record anyway. So I will take this under advisement, and we'll go off the record here at 1:47.
Thank you.